In this video, we'll be considering the issue of detention in non-international armed conflicts. And in thinking about that issue, we'll want to distinguish various different ways in which international humanitarian law regulates detention generally, and then focus in on those dimensions of detention regulation where there's the greatest gap, or at least would appear to be the greatest gap, in regulation under non-international armed conflict, international humanitarian law, bearing in mind that this is one of those areas of IHL where the gap between international and non-international armed conflicts is, on its face, the greatest. So we want to distinguish these various different ways in which detention is regulated in international humanitarian law. And we can think of several. So the first would be the grounds of detention. What's the basis on which a particular actor, party to a conflict, has the authority to detain and indeed to continue to detain? The procedures, particularly the procedures pursuant to which those grounds would be evaluated. In other words, pursuant to which it would be determined whether there is in fact the authority to detain in this particular context. We can distinguish those from rules relating to the treatment of detainees, or indeed rules relating to the material conditions of their detention. We want to identify which of these is, or which of these are, the areas in which there is a significant gap between the regulation of detention under international armed conflict and the regulation of detention under non-international armed conflict. I want to consider, having identified that gap, is there a way of identifying international humanitarian law that would fill that gap by implication? So is there an implicit filling of that gap, an implicit authority in non-international armed conflict, international humanitarian law, and what exactly would that argument for implicit authority be? We'll then want to consider several different ways in which different actors or authorities have sought to address this question. In the first instance, we'll consider the position of the United States, and want to be thinking in particular about the way the United States approaches these questions associated with, in the first instance, the grounds of detention, second instance, the procedures of detention, and how those grounds and procedures relate to the grounds and procedures of detention in international armed conflicts. When we're looking at the United States, we can look at the 2012 National Defense Authorization Act, the Department of Defense Law of War Manual, and the 2016 Law and Policy Framework on these issues, and think about how these questions of grounds and procedures, the detention in non-international armed conflicts, are articulated across those different documents, and how those grounds and procedures relate to the grounds and procedures appropriate in international armed conflicts. And we can think about the way that some of these approaches then manifest in the particular instances that we'll look at, such as the 2018 Al-Bahani litigation, the way in which this comes up in the course of that litigation, the 2022 Majid Khan habeas petition, and we can think also back to the Supreme Court exchange that we listened to in the Abu Zubaydah case that we listened to a couple of weeks ago, and think about how those various different instances of the application of this framework raise questions about how to understand non-international armed conflict detention authority, particularly with reference to these questions of the grounds and procedures. So we'll start with the United States. We'll also want to consider the Copenhagen principles on these issues of grounds and procedures and the relationship between the international armed conflict framework and the non-international armed conflict framework that's being articulated in those principles. So the